Hello, and welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy, and I'm a marketing manager here at Schoeneck King. Just two quick housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows. Once today's webinar has ended, we would appreciate you taking a moment to complete the brief survey. Your comments and suggestions are important to our panelists and provide us with topics for future presentations. It is now my pleasure to introduce today's moderator, Andy Bobrick.
Thank you, Kathy. Good afternoon, everybody. Good afternoon to our panelists. Great to be with you today. We have, I think, a number of good topics of interest to talk about here, and some great panelists and members of our firm here to convey some helpful information. Just to echo Kathy's point, please do, if you can, take 30 seconds and just respond to our survey at the end. We do review that information every week. We want to make sure that these webinars provide information that's helpful and timely to you. As I've said before, if you have ideas in the meantime or during our webinar for topics, just shoot them into the Q&A. Let us know what they are. We do take those under consideration, and again, want to be responsive. So before we dive into things here, I wanted to just mention one thing. I was on a call with a client, so I hadn't had a chance to check on this within probably 45 minutes or so, but there were several different media reports that were mentioning the CDC's likely changing of its masking guidance. Again, guidance from the CDC, not necessarily requirements, but guidance, indicating that indoor mask usage could be encouraged for vaccinated persons in certain areas where there are higher infection rates. Again, that's what is being reported currently. When I checked last, there was nothing official from the CDC as of yet. Also wasn't entirely clear what those areas would look like, what the thresholds would be, where the indoor masking of vaccinated individuals would be required. And then whether this would impact New York, the metropolitan area, and our surrounding states as well. More to report on that. Maybe it'll come out in the course of this webinar, and by the time we're done, Katie Anderson can fill in some of the information. We'll report more on this. If you don't, please, and you'd like to be updated, please check in with our blog. You can register to receive updates on our blog, the New York Labor and Employment Law Report. Okay, just wanted to mention that quickly. Next, I want to turn it over to my partner in our Buffalo office, John Godso. John is somebody who I work very closely with. John works in our employee benefits practice group. And John wanted to talk a little bit today about educational assistant benefits and student loan reimbursements. John, I know this is an issue that you and I have worked on together in the past, and that we do get questions on from time to time in our clients. So John, great to have you with us. Thanks.
Thanks, Andy. Hello to everyone. Glad to join the webinar this afternoon. Yeah, as a little background, we've been getting more and more questions as a firm related to educational assistance benefits, and in particular, tuition reimbursement, loan tuition reimbursement benefits that may be offered pursuant to Code Section 127. A little bit more background, we're finding some clients are having difficulty either attracting or retaining talent. I think this is consistent with some of the stories we see on national news. So we're really trying to look and help clients use all the elements in their toolbox that they may have in order to both attract and retain the necessary talent they have for their workforce. Obviously, one way of doing that is with respect to salary and wages, but there are other considerations that you can look to with respect to modifying your benefits. And one benefit that some employers are looking at are the educational assistance loan reimbursement programs. And the big advantage of those programs, if structured properly, these can be done on a tax favored basis to the employee. So both they're getting a benefit as far as the reimbursement amount, and that amount is tax free. So they are kind of a win-win for employees and a good tool for employers to consider with respect to, again, attracting and retaining talent that they may be looking for the workforce. So let's just start with a quick overview of Section 127. So Section 127 has been around for a long time. Many employers may already have a Section 127 plan in place. And basically what it provides is that gross income doesn't include amounts paid or expenses incurred by an employer for qualifying educational assistance. And you may see this often with respect to providing this assistance to your employees to increase their education, maybe get a master's degree, maybe a doctorate, depending on your particular field. And it's really an advancement of the employer's interests. There are limits on these benefits under 127. Currently under the code, that's 5250, and that's an annual limit. And so again, like I said, Section 127 has been around for a while. What's changed in the last year or so is that the CARES Act, if you recall that back in 2020, one of the earliest pandemic relief legislation that we received, provided that, all right, we're going to amend Code Section 127 to not only provide for current educational assistance, so you're sending your employees to increase their knowledge, get additional education, but also you could reimburse them on a tax-free basis with respect to student loans that they may currently maintain. And so, of course, that education would have been done previously for the loan. So now it really gave employers a more broad spectrum of expenses they can reimburse, and these were attractive benefits to employees. Now, the CARES Act provided for a sunset date of December 31st, 2020. However, near the end of 2020, Congress decided this was a good idea to extend this benefit. So in connection with the Consolidated Appropriations Act 2020, Congress extended the period for these tax-free loan reimbursements to a new sunset date of December 31st, 2025. So this allows employers who may have implemented this in 2020 to continue that program, and for employers that did not implement it in 2020 to consider doing that during the sunset period or this 5-year period. Now, again, we never know what Congress will do, and it may get extended further, but as of right now, 2025 is the end date for these programs. If we go to the next slide, please. So let's talk a little bit about 127 basics, because there are some parameters that you need to consider when developing your plan. So these are apply to 127 traditional programs where you're providing educational assistance, and they also apply to the new benefit of being able to do loan reimbursement programs. First, you have to have a separate written plan. Now, this can be a policy in connection with your handbook, for example, or can be a plan document itself, but you have to have something in writing. The plan can't be discriminatory in favor of employees who are highly compensated. So this often trips folks up if they're just looking to provide maybe higher education degrees, MBAs, et cetera, for a certain portion of their workforce. You can't be too restrictive in the way you design these plans. They have to be generally applicable to your workforce. So that's one issue to consider when you're setting up a 127 plan or a loan reimbursement program. For example, you couldn't just do it for the CFO or the CEO. It has to have a broad application. You can't provide any, similar to that non-discrimination provision, you can't provide more than 5% of the benefits to 5% owners. Again, it's got to be broadly available. You can't provide employees with a choice between educational assistance and other taxable income. So if you're familiar with the choice option is usually embedded in a cafeteria plan, for example. This can't be provided as an employee choice. It has to be a straight up employer provided benefit that's not provided through a cafeteria plan. And the employer has to provide reasonable notification of the program. This doesn't have to comply with, if folks are familiar with the ERISA requirements that usually apply to ERISA plans. This is not an ERISA plan, by the way. It's a product of the tax code section 127. So you don't need to comply with the ERISA requirements, for example, summary plan descriptions, et cetera. But we need to provide reasonable notification to employees of the availability of the program. Go to the next slide, please. So what are some of the design considerations that we see employers looking at when looking at trying to develop one of these plans? First, the first question is really eligibility. Who do we want to allow to be eligible for this program? And one consideration may be, if we're just trying to attract talent, are we going to limit this to new hires? And obviously, There would be considerations around surrounding that as far as employee relations, if you just limited to new hires and didn't have your current workforce eligible for it. So that's a consideration that you have to take in place when you're looking at these programs. Waiting period, you require employees to be there for 6 months or a year or some other period in order to be eligible for the benefit. That's often a component of a Section 127 plan, including loan reimbursement arrangements. And classifications of employees. Are we going to make it available to all employees who work for us, or are we going to limit it to a certain classification of employees? Now, again, we discussed a little bit that you have to have those classifications have to be non-discriminatory. So you got to be careful as to who you choose if you are limited to certain classifications, but you are able to do that to just provide for certain employees as long as that's non-discriminatory in favor of highly compensated individuals. What about your benefit structure? Are you going to provide, again, the statutory amount is $5,250, and that's a combined amount. So if you have a traditional educational assistance program and a loan reimbursement program, the $5,250 is combined for both. Are you going to do the full $5,250 or a different amount? You can do more than $5,250, but that amount would be taxable income to employees. So something you want to consider. Historically, some employers maintain loan reimbursement programs, but the full amount was taxable until, of course, the CARES Act came around last year in 2020. But a consideration is if you want to structure a hybrid taxable, non-taxable type benefit. Do you want to provide the benefit over multiple years? Will it just be the first year when you're hiring someone, or do you want to do $5,250 over a number of years? That's a possibility. Do you want to pay it out in a lump sum or prorate the benefit over each month, for example, that the employee works? So there's a lot of considerations that go into designing the particular benefit. And some other considerations can include providing for what types of degrees are we going to reimburse? Is someone, or what type of loans are we going to reimburse? Did they actually have to attain the degree, or any type of loan are we going to reimburse under our program? And what about any kind of post-payment service obligation? If we do end up paying out a certain amount, say it's $5,250, or we're going to require individuals to pay back that amount if they aren't employed by us for a certain period of time. So these are all considerations that go into putting together a program. I think the takeaway is that these are now available to us under the law, at least for the period until the end of 2025. And if you're considering modifying your benefits to attract or retain talent, it's one of the tools that you can consider to do that. So these are plans, obviously, that we can assist you with. And I think we'll see more of these in the future. Thanks, Andy.
John, thanks a lot. That was really helpful. And I can speak to this too. It is, especially as you point out, where recruitment and retention is an issue that so many employers are facing. This can really be a helpful tool. If you have particular positions that require a certain level of expertise or education, you can help your employees get there on a tax favored basis. And this is something that John and our partners in our employee benefits group can jump right in and help you make sure you have all your T's crossed and your I's dotted. So John, thanks again for joining us. So next we have another regular here on our webinar, Kate McClung. Kate is a partner in our Rochester office who also practices in the labor and employment area, somebody who I work with closely and have the pleasure to do so. Kate and I also work in the wage and hour area. Kate does a lot of litigating, class and collective action litigation in that area too, and is tremendously knowledgeable. Here, Kate had asked to come on and talk a little bit about some of the wage and hour issues that we as employers will face in this continuing dynamic of having our employees work remotely, whether part-time, full-time, whatever it is. And just to make sure that you all are keen to those issues and are able to keep an eye on them. So, Kate, thanks again for being here today.
Sorry. Okay. Thanks, Andy. Good afternoon, everyone. So obviously last year, many companies across the country had to very unexpectedly shift to have most of their employees work remotely. And that was a change that normally you would spend months thinking about how you were going to do it, making sure that you're complying with all the laws. that you need to comply with, and any differences that stem from remote workers versus in-person workers. But there wasn't time to do that. We had to very suddenly shift to remote workforce. Now, a year and a half later, we're starting to see a spike in litigation stemming from employers who shifted to remote work, but goofed some stuff up on the wage and hour front. So I had asked to talk today about this topic because I think it's very timely. A lot of employers are, it's not too late to go back and retroactively fix things if you did make a mistake over the last year and a half. Also, if you're thinking about continuing to have remote workers going forward in large scale or even just part of your workforce, these are some good things to think about in putting together those plans. So the first issue is meal breaks. Obviously, there's meal break requirements in New York State. There is no exception if the employees are working remotely. If they're working certain lengths of shifts during certain times of day, you still have to provide them with that meal break. If you have an auto deduction policy, those are lawful, but you do want to make sure that you have a way for employees to report when they missed a meal break. So you do make sure that they get paid for that work performed during a meal break. That's, sometimes that wasn't as essential when people were in person. They could just stick their head in their supervisor's office and said, hey, I'm going to work through lunch today. With remote workers, you want to make sure that you have a real clear-cut documented process for doing that. It's a good idea with in-person workers too. It certainly doesn't hurt. But some companies had kind of gotten away with not doing it for in-person workers, but with remote workers, it's all the more essential to do that. Next slide, please. It's also important to keep in mind your record keeping obligations for your non-exempt workers. You have to keep accurate timekeeping of their hours. When they're working in person, people come in, they punch a clock at the beginning of the day, they may punch in and out for their meal break, and then they punch out on their way out the door. We found that increasingly remote workers weren't working continuous shifts. Someone might work a couple hours in the morning, they might take a couple hours off for lunch, and then they might do a couple more hours in the afternoon, take some time off for dinner, and maybe do a couple hours at night. A lot of people took advantage of that remote work to have a more flexible schedule and to have their work spaced more throughout the day. But it is important as an employer that you capture accurately all of their start and stop periods for that work, and that you pay employees for all of their hours worked as well as overtime. So you might want to think through, okay, how have I been documenting that time work, and is there a better way to do that? There's so many options these days. There's lots of apps, there's lots of programs. So there's lots of options for doing that, but you want to make sure that you pick a good option that really reflects the fact that these employees are working remotely. Also, there may be additional payments that are due when that didn't come into play if your workforce previously was working just continuous 8-hour shifts, 9 to 5, Monday through Friday, that you may not have thought about, especially if your workers have been working these more interspaced periods throughout the day. So in certain industries in New York, you have to pay spread of hours pay if the interval between their first punch in and their last punch out was more than 10 hours for the day. That's different than hours worked because you count all that break time in there too. There's also split shift pay rules if there's a gap in the day of more than an hour. And so it's important to keep those in mind, that those might be due as well, especially for employers in the miscellaneous and or the hospitality industries in New York. Also, there's a call-in pay provision in hospitality and the miscellaneous industries wage orders in New York. Traditionally, that was always when the employee actually shows up in person to work. But now, increasingly with employees working remotely and their home being their work site, it's possible the New York Department of Labor may take an expanded view of that as well. So stay tuned on that front. Next slide, please. Compensable wait time is another issue that results in a lot of litigation. So the standard, if an employee is waiting around for work, if they're just waiting to be engaged, it's not compensable. If they're engaged to wait, it is compensable. So previously you might have had employees waiting around in the office to perform work. You might have paid them for that time. But some employers, now that employees are working remotely, have felt, okay, well, that same time, now that they're home, I'm not going to pay them for. And just because they're at home doesn't conclusively mean that you don't have to pay them for that time. You may not need to pay them for that time, but you need to keep in mind all the factors. How long are these periods of inactivity? Is it 3 hours they're waiting around, or is it just 10, 15 minutes? Can they really effectively use that time for their own purposes? Are you requiring that they sit at the computer and wait for something to pop up, or can they really be doing anything around the house? Could they be leaving their house for periods of time? Do they need to be in a certain location? So it's important to really think through that. Compensability of this time, of wait time, is very fact dependent. So it's important to keep in mind all those factors. Next slide, please. Another issue that's come up a lot is expenses. So employees have had to incur some expenses to work remotely. They may be using their cell phone for work. They may have had to buy a webcam or a printer. They may have had to upgrade their internet speed. I think all of us really rethought our approach to our internet speed last March. So generally, the federal rule is that the employer only has to reimburse expenses where it would cause the employee's compensation to decrease below minimum wage, or where it would eat into the overtime pay that they're entitled to. New York also requires the reimbursement of expenses where there's an agreement to pay those expenses, including potentially a handbook policy, depending on whether your handbook policies create contractual obligations or not. And keep in mind, other states may have different rules about expense reimbursement. Next slide. Classification issues. So some employers reclassified employees from exempt to non-exempt when they started working from home, figuring, well, they're independent enough to do their work from home. I should just be able to pay them a salary. Then I don't have to worry about all these other complicated issues about tracking time and meal breaks and all of that. But that's been a huge area for litigation that we've seen as well. So it's important to keep in mind the entirety of the duties test. Just because someone's working from home doesn't necessarily mean that they're exempt from overtime. Next slide. It's also important to keep in mind, so far I've been talking about federal and New York law. Your employees may not be working in New York State anymore. They may have moved. And so now they might be entitled to rights under the laws of different states or even different cities. An increasing number of cities, especially large metropolitan areas, have been passing their own employment laws. So for example, Chicago has a paid sick time law that if an employee works a certain number of hours in Chicago in a year, they're entitled to paid sick leave under that law. And so you really need to think through and do some research on where are your employees working. If it's outside of New York, are there other laws that are going to apply to those employees, either under the state where they're working and or the city where they're working? There may be wage notice or pay stub requirements. There may be different meal break rules. There may be different overtime rules, both in terms of exemptions, who's exempt from overtime. Some states have more narrow exemptions than federal law. So even if an employee would be exempt from overtime under federal law, they may not be exempt under a state's law. Also, entitlement to overtime might be different for your non-exempt employees. Some states entitle employees to overtime if they work more than 8 hours in a day, regardless of how many hours they work in a week. So that's something that's also important to keep in mind. I mentioned expenses, that different places may have different rules about expenses. We talked about additional payments in New York, like spread of hours, split shift. Other states have additional payment requirements like these that may be triggered because your employee may be working there now. There may be different posting requirements or record keeping requirements as well. So these are all things that you want to look into and be aware of. Next slide. So one final issue to leave you with is, what about withholding taxes for employees working in different states? Well, you're going to have to look both at the law where the employee would otherwise be working, so say New York, if that's where the job is located, as well as the state where they're actually doing the work. It is possible that if you look at the laws of both of those states, you need to withhold state taxes for both of those states, not just one or the other. It's going to depend on the interplays of those two states' laws. So it is important to keep that in mind and look into that as well. Thanks, Andy. I'm going to turn it back to you.
Okay, thanks a lot. This issue continues to persist. I know at least weekly, sometimes multiple times a week, I'll get questions on this. And I think it goes back to 18 months ago when we were first dealing with this and people were working from home, they were working in different areas, and we were all just kind of getting by, right? And putting out the many figurative fires that we had to deal with. And now that these engagements and relationships are starting to be more long-term, we're seeing more inquiries from clients about things like, hey, yeah, what will happen if I have an employee worker remotely in California? And PS, potentially a lot that you need to keep in mind. And do I need to register in this state to do business? The income taxes and those issues that you mentioned, Kate, all I think are things that need to be considered and considered carefully. And certainly Kate and others here at Bond are happy to assist you and your operations with that. So before I turn it over to Katie for the latest on what's going on in Albany and with the CDC, I just had a few questions from the mailbag I wanted to pull out and address very, very quickly with the group here. Again, these are things that we're tending to see, but keep your questions coming. We'll try to always address them as best we can. Masks at work, that continues to be a question that we get. As things stand now, my understanding is that New York State is still following the CDC's guidance. As I alluded to earlier, that guidance is seemingly set to change in the very near future. It remains to be seen how that will impact New York. I think there's been some other developments in terms of CDC's guidance that Katie will talk about in just a second. But again, as things stand right now, New York is still following the CDC's guidance. The deadlines for the HERO Act, I feel obliged to say here, hopefully all is going well with clients and friends of the firm with respect to getting their plans set and adopted and ready to roll out. I've been a bit surprised by the lack of inquiries on this issue. And again, maybe it's just people are ready and they know what they need to do. But don't lose sight of that deadline. You need to have your plan adopted by August 5th. And then after that, you need to have communicated that plan with employees and taken other actions. And so in that case, you're looking at either 30 days after the adoption or 60 days from when the guidance was originally published back in early July. So again, keep that August 5th deadline in mind. It's fast approaching and you're going to want to have your ducks in a row by then. Another question that we're getting with some frequency is basically, yes, we understand there's industry specific guidance, but we have some employees who work in the field. We have office employees. We may have other employees that fall in another category. What should we do? And then, of course, there's the model kind of generic template and plan that's out there too that the state has published. We're working with a number of employers on this. The guidance doesn't address what you should specifically do in this circumstance, but we've come up with, I think, a couple workable plans on how you try to piece things together in a way that makes sense and to have an effective plan for your business or organization. Ultimately, you're going to want to work with legal counsel on this issue and find a strategy that makes sense for your organization and that you're ultimately comfortable with moving forward. But again, we think there's some strategies on how to address that specific issue. Just two PSs on that point. And this is where I think working with legal counsel is important. If you diverge in what I would characterize as a material way from the standard model plans. So if you come up with your own alternate plan, then there's an obligation for you as the employer to get meaningful input from your employees about that plan before it's adopted. No definition of what meaningful input is. That's something we can work with you to try to identify a compliant path, but keep that in mind. Additionally, if you have a labor union in place, you need to obtain agreement from that labor union if you are putting an alternate plan in place rather than simply adopting one of the model plans. And again, this issue can get somewhat complicated when we start talking about different employee groups potentially covered by different plans and how do we synthesize and incorporate all of those different plans into a single document. So again, keep that point in mind, and I encourage you to work with legal counsel on that issue. Another issue we're seeing is a question, really, or a sense of people looking for more input. Are more employers requiring COVID vaccination among employees. I'm not seeing that. We touch base fairly regularly here as a department in labor and as a firm. I think where we've seen it is in the healthcare sector and in the colleges and universities, but we're not seeing it still with any great traction within private industry and organizations. But I'm also hearing anecdotally, more information, more discussion, more encouragement from elected officials and others looking at private sector employers and encouraging them to mandate COVID vaccination. Notably, just yesterday, the U.S. Department of Justice published a memorandum. Again, it's guidance. It's not binding authority, but it's insightful guidance, and essentially taking the position that employers can mandate, private sector employers can mandate vaccination among employees, specifically that is not somehow prohibited by the emergency use authorization approval that the vaccinations were subject to. That's been often cited in litigation so far as a potential hurdle for employers mandating vaccination. Thus far in the courts, that point has been pretty soundly rejected, and now we have the Department of Justice echoing that same sentiment and potentially providing employers with flexibility. Keep in mind, employers, if you are going to take that action in the private sector, you do need to be mindful of the potential to provide an accommodation based on an individual's sincerely held religious belief or their qualifying disability status. And finally, what about all these records that we generated relating to COVID? When do we have to keep them? Can we destroy them at some point? Sometimes these records will fall under another category, such as a workplace illness or injury, or a workers' compensation record, or an ADA covered record. And of course, you should default to those statutes and make sure you're keeping those records in accordance with the prescribed timelines. If you have questions on that, I encourage you to work with legal counsel to get the guidance that you need on that. Additionally, some of these records fall really outside the scope of the statute. I think the advice you may get on this will vary, but I encourage employers to keep those records certainly for the time being and for the foreseeable future. Again, we just don't know how things will progress, where issues may arise down the line. So I think it makes sense to keep those for the time being, particularly if we need to demonstrate compliance with the various workplace requirements that were in place and that may remain in place in your sector with respect to COVID precautions. All right, so those were a few of the questions that we've gotten. We'll keep an eye on your additional questions that you submit and try to answer those in future programs as well. But without further ado, Katie Anderson is joining us from Albany. Katie and I, like I said, we do talk outside this webinar. We were exchanging messages during the run up here. And Katie, I talked a little bit at the outset about the guidance that we saw, well, not the guidance, the media reports that were coming out about the CDC potentially imposing limited requirements on vaccinated persons to wear masks indoors. I don't know if you have anything that you want to add on that. And I think you mentioned that there was some additional insight that we were maybe going to be privy to with respect to masking.
Yeah, so there's a lot of updates to talk about. I did all my slides yesterday because I've been doing interviews for the firm all day today. So of course, the day that I just said, oh, I'm going to get the slides done early, we have quite a few bombshells dropped on us. So I will discuss the CDC guidance, but I'll do it in the context of the slides that I already have in here for you. Again, like I spoke about last week, and I have been speaking about for, since the middle of July, we are seeing cases increase steadily in New York State. We are seeing, again, over 1,000 cases a day. It's interesting to look at the hospitalization numbers, though, and the death numbers in New York State. Again, whenever you have cases increase, the hospitalizations will increase afterwards. But when you compare New York to other states, New York's hospitalization rate is not rising at the same level that many other states are. So we're going to go through a few charts here, and this is going to provide the context for me to talk about the CDC guidance that's coming out. First up, this is what this chart is focusing on is the number of cases per 100,000 people, so per capita. These are the states with the highest number of cases per capita. Arkansas is in the front of that. And when you look over at the chart, at the fully right side column of it, you can clearly see that there is a correlation to vaccination rates. Places with lower vaccination rates are seeing a lot more cases per capita than places with higher vaccination rates, which is part of the reason that the CDC is coming out with this guidance. Part of the issue that you're also seeing is hospitalization rates per capita are also dramatically increasing in places where the vaccination rate is lower than 50% of fully vaccinated people. And just to compare it for comparison's sake, these are the states with the most amount of fully vaccinated people. And you're seeing these numbers, the per capita is much smaller. It's much lower for cases per capita, and then hospitalizations per capita as well. The only one that's over 10 cases per capita is Washington at the bottom of this chart. So this is why the CDC is coming today at 3 o'clock. They will be having a news conference where they're going to be announcing a few things. One, they're going to be recommending that fully vaccinated people wear masks again in public in certain places. It's unclear what their certain places are going to be, but they mean certain geographical areas, as in certain areas in this country where the case numbers are out of control. Part of the reason for this is what we discussed last week, which are breakthrough cases or fully vaccinated people getting sick with COVID or having COVID and not knowing that they're sick. We are seeing a lot more breakthrough cases with the Delta variant than we have seen previously. Maybe it's because the Delta variant is just so highly transmissible that we're testing more people. Maybe we've had that same number of breakthrough cases occurring, with all of the variants, or maybe there's something specific about this variant that makes it more likely that a fully vaccinated person will become ill or at least have COVID. They may never develop symptoms. They may never know. And looks like a lot of the fully vaccinated cases are people who don't know. So what's the CDC going to do? They're going to recommend masks likely in certain areas of the country. I would not be surprised if they just say everybody everywhere who's fully vaccinated should be wearing masks again. They will also be recommending that all individuals wear masks in school for the upcoming school year. I know that's been a bone of contention for a lot of places, but they will be saying that everyone in a K through 12 school wears a mask this year. That's really ultimately so that schooling can happen this year in person. And so keep your eyes out for that guidance. Again, it's coming out at 3 o'clock today. They're going to be issuing this guidance. So, we will obviously keep our eyes peeled for it. And I encourage all of you to keep your eyes peeled for it as well. These are the risk levels again in New York State, just worth, looking at what's happening in the state itself. Going forward, and it looks like the rest of okay, there's the rest of the slides. So fully vaccinated progress in New York. New York did not change any percentage points this past week. And so again, of concern, the governor did say yesterday, we have 75% of people who are 18 and older with 1 dose. He was doing a little bit of exaggerated rounding up. It's really closer to 74%, but we'll take what we can get. The state is now allocating its approximately $15 million to trying to increase vaccination levels in areas where zip codes, the lowest zip codes for fully vaccinated rates. 79% of the low vaccination rate zip codes in New York are New York City and Long Island. The rest of those 21% are all throughout the rest of New York. Here are the zip codes here. This is from the governor's PowerPoint yesterday. Only reason I had to include it is very rarely does the zip code 13733 show up on anything, which is where I grew up. But don't worry, Bainbridge, New York made it right onto the lowest vaccination rate list on this. So what is the state going to be doing? The state will be partnering with nonprofits and advocacy groups to increase vaccination rates in those areas. I think that we're going to see a lot of changes occurring in the next week or the next 2 weeks because of the CDC's announcement that they're making today. I think that's really going to color a lot of things are about to change in a way that we may not want them to, but they're going to. So be ready for that, be on your toes, because I think that a lot of this is going to be in flux over the next few days. I think that the state vaccination efforts, that's going to be very important to keeping the numbers down in New York. But it will, we'll see how it goes ultimately. New York City has issued a vaccine mandate. It's not necessarily a mandate so much as all municipal employees must be vaccinated by mid-September or must be tested weekly for COVID-19. There are very low rates of vaccination in certain areas of New York City's municipal workforce. The NYPD, corrections, and the fire department all have pretty low vaccination rates, especially when you compare it to like the Department of Education, which is at about a 60% vaccination rate. Still not necessarily where you want that to be. That's not herd immunity. It applies to teachers in New York City. Yesterday, the governor gave a press conference saying that the state won't be issuing a vaccine mandate. The state won't be issuing a mask mandate again, really, even though there is still one that exists in New York, technically under the Department of Health regulations at this moment for unvaccinated people. But saying that it's going to be up to localities to decide if fully vaccinated people need to be wearing masks again. It's going to be up to localities to decide if they are going to mandate vaccines for their own workforce. That will be, something to be watching out for. And that makes all of our jobs a little bit harder, right? Because now we're no longer looking to what the state is necessarily saying. We will have to be focusing on your individual counties, your individual cities, to see what's happening in those areas. Obviously, Bond is very well equipped to do that. We are all across New York State, so we have our fingers in every pot. But just know that it's no longer going to be just a visit to the Department of Health website. It will really be important to know what your local government is saying in terms of mandates. I expect we're going to see more and more of these occur. California instituted one for all state workers yesterday as well, right after New York City. So I wouldn't be surprised if the state ends up issuing one for all state employees, but we'll see. There's another issue that's coloring all of this at the same time, and that is all of the investigations into the governor. The governor was questioned by the Attorney General about 2 weeks ago. There's lots of indications that the Attorney General investigation into the governor will be wrapping up soon. The contract that is for the attorneys that are running this investigation, the contract only is until September 7th or right after Labor Day, which indicates that the report should be coming soon, unless they, extend that contract. That to me indicates that we're going to see something in the next few weeks from that investigation. The Assembly is also running their parallel investigation. There's been some more drama surrounding that I won't necessarily get into. But you also have the federal investigation of an intentional cover-up of nursing home deaths. The Department of Justice did decide this week that it would not be opening a civil rights investigation into New York's state-run nursing homes and how they ran throughout COVID. That is consistent. They did that in a number of states. So that's not a New York specific one. That is, just for state-specific nursing homes, state-run nursing homes too, which is a significantly smaller number of nursing homes in New York State than private. I could have done the whole webinar at this point. I'm like running out of breath. Finally, here's our last topic that's worth discussing. There's been a lot of news lately about 2 delays that are occurring in topics that are important for a lot of our clients and personally and also in their professional capacity: rental relief and marijuana. So New York has the esteemed pleasure of being the only state that has not distributed any money from the federal relief fund to tenants or landlords. New York was allocated $2.4 billion. And since this was written, they've distributed $100,000 of it, but still. The governor released a statement yesterday that said that New York will be current with payments by August 31st. Ultimately, this is a huge issue because other states are running through their money, and people haven't, this is money for rent dating back to March of 2020. So a big issue. In the meantime, the Office of Cannabis Management and the Cannabis Control Board, which are the entities, the agencies that are in charge of putting forward the regulations that are going to determine how marijuana is sold, grown, and distributed in New York State. There has been no nomination, there have been no appointees for any of the open positions, which is really going to delay the work here. We're seeing that this is going to push out the legal sale of marijuana in New York probably by another 6 months versus when it was signed in March of 2021. The governor's spokesperson linked it to the state Senate's decision not to take up their governor's proposal, their last minute proposal to reshape the MTA. So this is going to be a topic that we're going to be watching very closely as well, because it will really impact what's going to happen with cannabis in New York State. So with that, Andy, I will kick it back to you.
All right, Katie, thanks as always. Appreciate the update. Very helpful information. Thank you again to our panel, John Godso, to Kate McClung, and of course to Katie. Great to be with you all today. We will see you next week. Be well, be safe in the meantime. Take care.